Welcome to Chapter 6, Contracts, the legal and ethical environment of business, or part of the legal and ethical environment of business by Terrence Lau and Lisa Johnson. This is Dr. J. Kent Gregory, and we'll begin our discussion of Chapter 6, Contracts. This is probably the most important chapter from a business person's perspective that we'll look at this term. Not that the other chapters aren't important, but this is, key to so much of what we do and how we set up what we do as people who are involved in business. So a little bit of introduction. So an implied covenant is a promise the law requires in all contracts, regardless of whether the parties state it or not. And then another concept is good faith, meaning the covenant or contract is concluded in good faith without deception. And then the contract itself. So this is a legally enforceable promise. That's really essentially what a contract is. So there are three different types of contracts. There's the express contract, which is a contract where the terms are explicitly discussed uh, among the parties. And of course, we're talking about something in writing here. An implied, in fact, contract, so this is a contract that arises from the conduct of the parties rather than through explicit discussion of terms. And then there's the quasi contract. This is an equitable remedy that's actually imposed by the court in the absence of a contract to avoid unjust enrichment by a party. So those are the three types of contracts. Some further concepts, damages. This is a compensable loss, uh, breach, the failure to perform duties or obligations in the contract. And then private law. This is a legally binding agreement between consenting parties that does not apply to the public at large. So private law, this is your contract. So that's what we have there, contract. So some other terms, elements of contracts that specify important matters such as quantity, price, time for performance. So you think about it, when you conclude a contract very often, there's a time period in which it must be done. Mutual assent, this is in common law contracts. It comprises the actual offer and then acceptance of the terms of the contract. And then something that we will talk about a lot in business is the non-compete clause. This is a contract clause that restricts competition for a specified period of time within a certain geographic region. So it can't be all across the world. It has to be in a specific geographic region and has to be for specified activities. So many industries do have non-compete clauses. For example, when I was in the insurance industry, we had a non-compete clause. But other industries don't, like financial management does not have a non-compete clause. So, if you're a financial manager, you can move your clients from one broker dealer to another. Um, but something to keep in mind. So, contract formation. Uh, Formation in common law refers to the offer, the acceptance, and the consideration. And those are issues that are terms that we'll talk about. In the US, contracts are primarily governed by the UCC Article 2. And of course, we'll be referring and have referred to the Uniform Commercial Code quite a bit already this term. So if all elements of a common law contract formation do not exist, meaning offer, acceptance, and consideration, then the contract may be void, uh, which refers to a contract that is not valid uh, or voidable. And this refers to the status of the contract that may be terminated due to some defect. For example, there was no real consideration. And that kind of brings us to the non-compete clauses that we'll talk about. So elements of the common law is the offer. This creates the power of acceptance in another party. If you make an offer, the other party now is granted the power to accept that. And in the offer, it includes the agreement's essential elements. which have to be definite, and that's very key. They have to be definite and certain. And then acceptance in common law, this is a mirror image of the offer, which says, I accept that offer. Consideration is a bargain for exchange. So this is essentially the money or equivalent that exchanges to cement the common law contract. So offer and acceptance together form mutual assent. So mutual assent, both parties refer to it. I agree to it, and this is referred to as the agreement. And then to be enforceable, contract has to be for a legal purpose, and the parties have to have the capacity to enter into the contract. So when we think of capacity, for example, people who are senile or suffering from dementia cannot legally enter into a contract. In a similar fashion, neither can minors. And this is somewhat related to all the stuff about Britney Spears and I don't mean to laugh, but all the stuff about Britney Spears that we've been hearing about in the news lately. Um, so in common law contracts, as we said, acceptance must be a mirror image. Uh, but if a counter offer is made, then that doesn't count as acceptance because then the counter offer then is essentially rejecting the original offer and it creates a new offer. And then once the offeree, this is the person who gets the offer, rejects an offer, either through outright rejection or through a counter offer, the original offerer is free to walk away from the failed negotiation. Um, and if the offerer revokes an offer before the offeree accepts, then the power of acceptance has been withdrawn by that revocation. And the revocation is a retraction of an offer before it's accepted. So we often see a lot of this happen when we do housing contracts. So some other things, advertisements are not offers, and some things to be very careful about are bait and switch advertising and race-based denial of services refusal to contract. You cannot do those things. Um, a common law contract can either be bilateral or unilateral. There's the mailbox rule, meaning once an offer and acceptance is valid and effective, when the offer deposits the acceptance, and in some cases, the consideration in the mail. And we saw this a lot, or we see this a lot in insurance. And all common law contracts must contain valid consideration. So this must be a bargain for exchange of acts or promises, and both parties must incur new legal detriment or obligations as a result of the contract. And then non-competes, which we'll talk about a good bit in class. And that brings us to the end, or almost the end. Some other things to think about is an illusory promise, something that looks like a contract but isn't, and then consideration. Uh, this is a further explanation of what we were talking about. So that does bring us to the end of part one, chapter 6.